The last question that we framed under Copyright Act is question number 5, which asks discuss the various exceptions to copyright infringement, and regarding that we will discuss the doctrine of fair use and the very circumstances of exceptions to copyright infringement. And as regarding the very doctrine of fair use or fair dealing have been invoked by legislators and judges to provide exception to copyright infringement. The moral justification for copyright is that a person should be able to reap the benefits of his or creation or mechanical labor. The doctrine of fair use seeks to limit that exclusive right to some extent in specific instances of overriding social interest. So, a copyright work can be used without the consent of the copyright holder to facilitate education, research, and the dissemination of knowledge and information for the promotion of the economy and culture of a society. The fair use doctrine is a valid defense when there is market failure or when transfer of use to the defendant will benefit society, or when such fair use would not cause any substantial injury to the copyright owner. So, some typical circumstances under which the exception to copyright infringement are invoked in terms of fair use or otherwise are: one is factual, material, and the second one parliamentary, judicial proceedings, advancement of education, research, etc. should show the public's right, and the criticism or review of such works and public reading should show recording to broadcast and showing to public, home taping, reproducing one's own work, and filming or broadcasting sculpture, work of art, reproduction in an artistic effort, and the backup copies of computer software and copies after permitted time gap and copies to advertise. So, the very first one, that is relating to factual material, is open to public inspection, and the second one is the any act was done for parliamentary and judicial proceedings are under the exception to infringement of copyright. So also the third one, acts done in pursuance of ends specifically authorized by the Copyright Act, such as advancement of education, use in libraries, and research in the course of instruction, performance in classrooms, broadcast recorded for educational use, etc., are falling under exception to copyright infringement. So also protection of the public's right to be informed through photographs, news shots, reporting of events, and the fifth one, used for the purpose of criticism or review, are also falling under the exception to copyright infringement. So also public reading or recitation of a literary work, and the seventh one, recording of a work by a party that is entitled to broadcast it, and the eighth one, that is showing of broadcast to public audience who have not paid for admission to the venue, is also another kind of exception to the infringement of copyright. And the eighth one is home taping of broadcast. And the next one, that is reproducing one's own work or using parts of it, is also another exception to copyright infringement. And the next one is filming and or broadcasting a sculpture or work of art that is publicly situated, is also not an act of infringement of copyright. So also reproduction of an article in an artistic effort by any person is also not an infringement of copyright. And also backup copies of computer software by any person would not be considered as infringement of copyright, as also it is falling under the exception to copyright infringement. And the next one is those copies made in situation where the author may be presumed to be dead for more than the time gap permitted for copyright to exist after the death of the author or the artist of the work, also would not be considered as copyright infringement. So it is another important exception to copyright infringement. And the last one, that is copies to made to advertise the product itself. So this should be considered as an exception to copyright infringement. And now we'll discuss the very provisions of section 52, which provides when permission needed for fair dealing. So, regarding that, we'll discuss the very provision of section 52 of the Indian Copyright Act 1957, as amended in 1999, indicates the incorporation of the fair use doctrine and explains what is not legally an infringement if fair dealing is not allowed and permission has to be obtained for every single use of any copyrighted information. The resulting high transaction cost of obtaining information would make the free flow of information both expensive and difficult. So, the very question that discuss the various exceptions to copyright infringement, and in that connection, as we discuss the very doctrine of fair use or fair dealing, it is very important in the context of those exceptions that we have discussed, as we found almost 15 different exceptions to copyright infringement and those circumstances as of exceptions regarding copyright infringement and those 15 exceptions we have discussed in detail, and regarding section 52 when the permission is needed for fair dealing, that also we have discussed in detail. So this should be the appropriate and correct answer to the very question. Discuss the various exception to copyright infringement.